very much for joining us today. My name is Ian Scott, and I am the managing partner at Scott Legal. And today we're going to talk about the different ways to move from a non-immigrant visa. So, for example, a TN visa, an H-1B visa, an E-2 visa, lots of different types of non-immigrant visas to an actual green card. So we're going to go through those details. In terms of a few housekeeping items before we get started, this webinar will be recorded, so we will send you the recording after the webinar, and we will also send you a number of other things. We'll send you a copy of this PowerPoint presentation that we're going to go through. We're also going to send you a link where you can set up a consultation. And then we're also going to send you a link where you can download a number of guides that are going to talk about the different visas that we are going to go through. So both the visas on the non-immigrant side, like TN, H-1B, E-2, et cetera, but also the visas on the immigrant side, the green cards, like National Interest Waiver, EB-1, et cetera. So we'll go through all of those, or there will be guides to go through all of those. To the extent that you do have questions, please feel free to add those questions to either the chat or the question and answer box. We will get to all questions. So without further ado, let us get started. So just first, before we get into a lot of the detail and the different types of specific visas, I just want to talk generally about the green card system in the United States, because it is different from the system in many countries. A lot of countries have a system where permanent residency, which a green card is based on a points system where you get a number of different points for different things. So, for example, if you speak the language, if you have a certain amount of education, then maybe the time that you've been in the United States, and then you get those points. And when you add the points up, once you reach a certain number, then you're able to apply for a permanent residency. But the United States is different, because the United States has a system where there are just a list of green card categories. And if you're eligible for the green card, then you're able to apply. And usually, not usually, in every instance, the eligibility doesn't have anything to do with the visa that you currently have. Just give me 1 second. Okay, for some reason, I think I was muted there for a second, but I think that that has been fixed. So a lot of the time people ask the question of whether or not a visa will lead to a green card, and the answer is always no. There's never an instance or a situation where a visa actually leads to a green card. Instead, what happens is that you have these green card categories that are listed here. So they're family-based green cards, employment-based green cards, and they all have criteria. And if you are eligible or you meet the specific criteria, then you can actually apply. And what we're going to do is we're going to spend the time going through each of these different areas. So now let's talk first about family-based green cards. And this is definitely a way that a lot of people move to, from an immigrant or non-immigrant visa to an immigrant visa. An immigrant visa is synonymous with green card. And so someone might be on an E-2 visa, and then they meet the love of their lives in the United States, and that person might be a U.S. citizen or a green card holder, and then they marry, and then they're able to get a green card that way. And there are lots of other ways as well. You might have a sibling in the United States where a U.S. citizen sibling, where an application was filed some time ago. And when the application was filed some time ago, then the application was filed some time ago, and then the category became current, and then you're able to file for the green card. So the way that this works is that broken up into two categories: the immediate relatives and the preference-based categories. Now, the difference between the immediate relative and preference-based categories is that the immediate relatives covers really a few areas. So, for example, it's not really what you would think of as normally what an immediate relative is, like for example, a sibling, et cetera, but they're defined under immigration law. So one example is that a U.S. citizen marrying someone else, that's considered the immediate relative category. Or another example is a U.S. citizen that is over 21 and they're sponsoring their parents. That's another immediate relative category. And the reason the immediate relative category is important is because that category is never backlogged or delayed. There are always green cards that are available. And there are often sometimes additional benefits for immediate relatives. So, for example, if you have a US citizen that's marrying someone, then the person can get other benefits. For example, if they're in the United States undocumented, they can still get a green card. And as well, if they are in the United States and you marry, or even if you're not in the United States and you marry a U.S. citizen, and you instead of having to wait 5 years to apply for citizenship, you can actually get the citizenship in 3 years. So, but a lot of our non-immigrant visa holders do adopt this route. Now let's talk about the preference categories a little bit. So the preference categories, they're defined, they're F1 through F5, and really what they're getting at is, so for example, a preference category is a U.S. citizen sibling that is sponsoring their brother or sister. Now, the reason the preference categories, another example is a green card holder that is sponsoring their spouse. And there are a number of different examples. So, for example, a parent sponsoring a child that is over 21 and married or unmarried. There are lots of different categories. Now, the reason that this is not as good as the immediate relative category is because the way the immigration system works in the US, and this applies to both employment-based and family-based immigration, with the exception of immediate relative category, the way that it works in the US is that there are a certain number of green cards that can be issued every year by country. And once those have been used up, then the people go on almost, I'll call it a wait list, right? So for example, if a US citizen wants to sponsor their sibling and they want to do that, they certainly can. However, the wait is going to be around 15 years or so before the green card category is actually current. So, and each of the categories, every single preference-based category right now is delayed. So there is always going to be delay, and you have to look at the visa bulletin to see exactly what that delay is. And keep in mind that philosophy or policy exists on the employment-based side too. So when we talk about the employment-based categories, we also will see that there are, in a number of instances, where there are delays because the green card has been used up. So it means that the benefit that you get associated with the green card or associated with filing is going to be delayed. And we'll talk about that a little bit more as well. So those backlogs are definitely important to keep in mind, because you have to make sure that you're maintaining some type of underlying visa status in order to make sure that you can stay in the United States. Now, the next thing I wanted to talk about is the process. And this process, again, although we're on the family-based slide, this process really is applicable for each and every one of the categories. And that is that when you're applying for a green card, there's going to be either a two-step process or a three-step process. So let's talk about we'll start with one that's a three-step process. So there's always going to be the first part of the process where it's, maybe we'll call it a little bit more objective, in the sense of it's proving that you meet the eligibility. So on the family-based side, if you say you're married to a U.S. citizen, you're going to file a I-130, and that I-130 is proving that it's a bona fide marriage, that it's a real marriage, not a sham marriage. And that's always going to be the same, even under the employment-based category. The first step is going to be proving that you meet the requirements. And now the second step then is going to be one of either doing what's called consular processing or adjusting status. So if you're in the United States, you can do something called adjusting status. If you're outside of the United States, you do something called consular processing. Now, the other thing to keep in mind, though, is you can only consular process or adjust status, because think of the consular processing and the adjustment of status almost as the procedural part, the part that deals with making sure that you don't have any inadmissibility factors, making sure that the security checks have been done, et cetera. And this process is going to be the same across family-based, employment-based. It doesn't matter. The process is going to be the same, regardless of which one you're looking at. But when you are looking at the I-485 or consular processing, you will have to, you'll only be able to do those if the category is current. So we talked a little bit earlier about the visa being available. So let's say you're under immediate relative, then category is always going to be current. So if you're in the United States, you're always going to be able to file the I-485, or if you're outside of the United States, you'll always be able to file for consular processing. So there'll be no wait or delay. But if you are in a preference-based category, you may have a delay. Keep in mind that the exact same concept for the employment-based categories as well. And I said there is either 2 steps or 3 steps. So the last is that there are certain areas that have a 3-step process. And what that means is instead of giving the green card outright and giving you a 10-year green card, that instead you get what's called a conditional green card. And this is, for example, the good example of this is under the immediate relative category. If you're marrying a US citizen, 2 years after you get your green card, you have to then go back to the government and say to them, hey, yes, this was a real marriage, and give them proof that the marriage still exists and that it was actually a real marriage. So that's something to keep in mind, that sometimes, often it's just a 2-step process. But there are, both in the employment-based and the family-based categories, there are instances where there's a 3-step process. So after you have the green card for a couple of years, you have to then go back and communicate with the government again and show them that you continue to meet the actual conditions. One last thing before we move to the next slide is that when you file the I-485, you can also be, as I said, you're in the United States when you do this, and when you do this, you can also file for travel authorization and work authorization. So that's something that you can submit. And the travel authorization right now is taking about 3 months. The work authorization is taking closer to a year. But that's something that you can definitely do. And so it's a really significant benefit, because you may be in the situation where you are in the United States and you actually get to, you're in the United States and you actually get to live and work until the green card has been adjudicated, and that can be, that can take some time. So the next category we're going to talk about is an employment-based category. And the way that the employment-based categories work is they go EB1 through EB5. And the first one we're going to talk about is EB1A, which is extraordinary ability, and what the requirements are for that. Now, when we look at EB1A, we are looking at someone who has risen to the top of their field and has met the requirements for extraordinary ability. And typically the visa that we see people moving from, the non-immigrant visa that we see people moving from here, is an O1 visa, because the criteria for O1A in particular are very similar to the criteria for EB1A. But when we think of EB1A, we should really be thinking of almost like an O1 squared. So just much more difficult to get the visa benefit, just because much more difficult to get the visa benefit just because the requirements, even though they may look the same on paper, that they are more difficult in essence. And what you have to do is you have to meet at least 3 of the 8 criteria that are listed on this listed on this slide. So the key here is that you are, for example, let's go through a couple of examples, that you've judged the work of others. So we think of, they're all getting at areas where the person has risen to the top of their field. And if they've risen to the top of their field, then they if they've risen to the top of their field, then they have demonstrated that they are, at the top. So when you think of the traditional judging the work of others, look at American Idol or something like that. And when you are looking at American Idol judges, those are all people who are accomplished musicians and things like that. But there are lots of examples of judging the work of others. So, like, they also say that, for example, if you have a particularly high salary, then, with the particularly high salary, that if you're paid a lot of money, then that means that you are someone who has actually risen to the top of your field. It could be that you have a lead or critical role in a distinguished organization, and that's something as well that it shows that you have risen to the top of your field. And the last bullet point on the slide, it looks like that's something that'll be removed, so that no need to pay attention to that. So the other thing to think about with the EB1A extraordinary ability is that you can actually self-petition, right? So you don't need a job offer for this, which is great. So you can actually self-petition, and you can file the petition on your own, right? So that's great. You just don't need an employer. When we look at the process again, this particular one is a 2-step process. So you're going to file an I-140. So the I-140 is going to show that you have met at least 3 of these criteria. And then the other thing to think about when you're looking at these criteria is that meeting 3 of them alone, unfortunately, doesn't just mean that you're going to get the green card, because what the government does after, when you have actually met 3 of the criteria, they then do a secondary analysis that says, okay, well, overall, we're going to look at this person and see if they have risen to the level of extraordinary ability, and that's a fairly subjective analysis. So now we look at the second part of the process, which again is just the I-485 and consular processing. Now, again, though, we have to look at whether this category is current, and this category is current for most countries. I don't know if it's current. I don't think it's current for India and China, but it is current for most countries. So that's something that is, if you are in the United States and you have filed an I-140 petition, you can file the I-485 concurrently. You can also premium process one. You can premium process this one. You can pay the government $2,800 and have an answer in 2 weeks. So that might be something to do, which is beneficial instead of doing the I-485 filing. 485 filing, doing first looking at whether or not you have gotten the approval and then deciding whether you do the I-485 filing. And that's going to depend on the type of visa that you're on. As I said, normally people move from an O1, but there are instances where people move from other visas as well, the H-1B, TN, or even E2 to EB-1A. And sometimes we even see under the entrepreneur category, people who have received a claim, they have received kind of sponsorship in sophisticated or well-known distinguished incubators and things like that. They've received a lot of investment. People are writing about them in the newspaper, things like that. That can also meet the EB-1A criteria. So now the next one we're going to talk about is EB-2. Now, EB-2 National Interest Waiver. Now, keep in mind that EB-2 National Interest Waiver, it's something that a lot of people talk about, and we get a lot of requests for people who are interested in National Interest Waiver. The EB-2 category itself has 2 components. One is National Interest Waiver, and the other one is PERM, a company sponsoring you for a green card. Now, I know it's at the bottom of the slide, but I want to talk about it first. Before you even get to what I'll call the hard part of National Interest Waiver, then you have to first meet the threshold requirements of EB-2. And that is, you either have to have an advanced degree, so that's going to be a master's degree or higher, or a bachelor's degree plus 5 years of progressive work experience, or something called exceptional ability. So exceptional ability, there's 7 criteria, and you have to meet 3 of them. So that's not the same as extraordinary ability, but the things to keep in mind is that, so for example, let's say someone couldn't do advanced degree or bachelor's plus 5, let's say they only had a high school degree, they could still possibly qualify under the National Interest Waiver category under exceptional ability, but if they meet at least 3 of the 7 criteria. And we do have separate webinars on each of these topics. So we have webinars on National Interest Waiver, on EB-1, so definitely we touched on these a little bit here, but certainly if you want more in-depth explanation, I would advise you to attend one of those webinars. And we do regularly host webinars, and whenever we do, we post those onto our YouTube channel. So now let's go to the actual requirements of the hard part. And the hard part of National Interest Waiver, it is based on a case. It's called Danisar, and you have to prove 3 things. So the first thing that you have to prove is that the endeavor is going to be either has some substantial merit or be nationally important. And so to do that, we're often going to, it could be that you're talking about job creation, economic benefit. It could be that you've invented something. It could be, any of those things could work for national interest waiver. Then you're going to have to show, and usually we'll do that through expert opinion letters. We can do it through articles. Like if the government says that this is something that they find important, that can be something that we can utilize as well. The person's well positioned to advance the proposed endeavor. That is, you're going to show their experience. You're going to show maybe track record. If the person's an entrepreneur, show that they've received investment, that they've capitalized the company. All of those things are going to be important to show that the person is well positioned to advance the endeavor. The government really likes a track record here. Although this is a forward-looking petition, the more you have done, the better. And then the final requirement is that the government should waive the labor certification process. So that's something that you're going to point to some of the things in prong one and prong two, but also anything unique about the individual that shows that they're well positioned. Now, the filing here as well, it's similar to the last one. Similar to the last one, the EB1A, in the sense of two things are similar. One is that you're able to self-petition, so you don't need an employer for this either. There are, again, we do a lot of national interest waivers for entrepreneurs, and that it is a two-step process for this as well, where you file an I-140 showing that you've actually met the national interest waiver criteria, both the threshold criteria, and you've met the three prongs of the Danisar case. And then the same consideration if you are in the United States and you are, you're in the United States and you are going to file the I-485, or if you're outside the United States and you're going to do the consular processing. So all of those things are interesting to keep in mind. Now, for national interest waiver, in terms of the types of petitions, people move from, in terms of non-immigrant visas, we do a lot of E2s to national interest waiver. We do some TNs and H1Bs to national interest waiver as well. So really, it is about looking at what the person is coming to the United States to do, what is their proposed endeavor, and then seeing if we can build a national interest waiver case around that. EB2 perm and EB3 perm. Remember how I said that EB2 is broken up into either national interest waiver or perm. And so EB2 perm just means it's professional. So these are all companies sponsoring you for a green card, right? And now the company sponsoring you for a green card, either under professional category, but you can also do the company sponsoring you for a green card under even unskilled worker, and that would be under EB3. So there's perms we've done for, we've seen dishwashers, we've seen nannies and things like that. So there are lots of different categories. And really what they're trying to do here is show that the individual, that there are no qualified U.S. workers to take the position. That's going to be the overwhelming or overriding criteria for being able to get either EB2 or EB3. And keep in mind, you still have to meet the EB2 threshold criteria if you are applying under EB2 as a professional. And the way that the perm works, it's a multi-step process where you're going to create a job description, and then you're going to send that to the Department of Labor to come back and indicate what the job should be paid. You're going to have to do kind of an artificial recruitment process, where you're going to have to place ads and interview people. And really what you're trying to see here, can you find a qualified U.S. person? If you do find a qualified U.S. person, then you have to stop the process and maybe try it again later. You do have to be conscious the Department of Labor does audit these, and sometimes things can trigger that. If you say, oh, I need someone with 10 years of experience just because your applicant has 10 years of experience, but that's not really what's required for the job, they could audit. Or if you say I need foreign language, the job needs the person to speak a particular language, that can be difficult as well. And that first part is a Department of Labor filing, and that's usually taking around 18 months to do, so it is quite a bit of time. Again, this is going to be a two-step process. For this, you obviously do need an employer, and the I-140 is going to be the first step of the process, and then I-485. And again, you have to look at whether the category is current or not. And family members, so children under 21, and for all these categories, it's similar. Children under 21 and the spouse can kind of join in the process. So now the last employment-based category is EB5. So there is another employment-based category, EB4, but it's a religious-based visa, and we don't do those at all. But the last one is EB5, and this is an investor-based visa where you're either investing $800,000 or $1,050,000 in a business, and the new commercial enterprise, so it's anything created after 1990. And the distinction between the two, whether it's 800,000 or 1,050,000, is that the one is for a targeted employment area. the 800,000. So that's an area where the unemployment rate is 1.5 times the national average, or a rural area. So that's, but the rest of the areas are going to be 1,050,000. And there, a lot of the time, this particular visa, we see people moving towards when they're on an E2 because they already have some investment. But however, we do see a lot of people moving towards other from other visas as well, because this is for starting a business or investing in a business, but also you can invest it more passively in a regional center. So we could have people on a B, we could have people on a TN or an H1B that just say, okay, I want a green card and I'm going to invest in a regional center, and that's what that's what I'm going to do to get the green card. So that's definitely something that we see as well. You do have to be a lot more conscious of because this is very different from an E2. It's different from the source of funds perspective. It's different from this one does require specific things. It requires 10 full-time jobs, for example. It requires the specific investment amount. So it does require a very, very specific thing. So that's something that should be kept in mind. And really you have to go through a pretty detailed analysis of what kind of how to move from an E2 to an EB5, if that's what you're doing under the direct investment program. In terms of I mentioned this already, that you do have to create 10 full-time jobs. And typically, if it's a direct investment, we're going to show a detailed business plan. And the investment does have to be linked to job creation. So that's going to be important. And then when you're filing the EB5, this is a 3-step process. So you're going to file an I-526 petition. And the I-526 petition is going to show that you've actually invested the 800,000 or 1,050,000. And then the biggest part of this, or the most difficult part of the EB5 petition, is actually the source of funds. So you do have to show where the money came from. And that is quite an exercise. So it's definitely not for the faint of heart. It is quite an exercise. And then once you get depending on whether you're in the United States and the category is current, once you get you either apply the I-485 or do consular processing. But once you get the green card, then 2 years after you get the green card, you have to do something called removing the conditions, and that is an I-829 filing. Just some other ways to get a green card you should be aware of. Diversity lottery, that's something that comes up every October. Every year we have at least one client that's usually doing an E2 or something like that wins the diversity lottery. So definitely worth checking that out. There are other humanitarian-based green cards, like, for example, if you're the victim of spousal abuse, or if you help police with a crime, that's something that, maybe there's a green card option that's available for you. Asylum, the different things like that. And then, of course, we always hope for immigration reform, where we get even more options. Some other things to consider, timing. So you always have to, when you're moving from a non-immigrant visa to a green card, you always have to kind of look at, well, what visa am I on right now? Which visa am I on right now? So if you're on a visa that's not a dual intent visa, which most are not, you do have to really make sure that if you're going through the green card process, that maybe you don't have to renew that visa during that time, because you might have difficulty doing it because the government will say you have immigrant intent. So in particular, the green card categories that take a long time to be processed. So EB5 takes several years to be processed, sometimes 4 to 5 years to be processed. So you do have to kind of make sure that you're looking at that in the context of, do I have to travel exactly, and what are my expiration dates, to make sure that you are maintaining your status, because you will, in a lot of cases, you will need underlying status. If you file an I-485 petition, if your category is current and you file an I-485 petition, then you're in good standing, because you're in a period of authorized stage during the time that the petition is pending. For an EB5 petition, for example, the petition could be pending for years, over 5 years. So it does give you the ability to live and work in the US. So that is very useful. And a lot of the people do parallel green card strategy. So they might file an EB5 and a national interest waiver at the same time, just to hedge their bets. So that's something that a lot of people do. Perfect. So that is the end of the shared remarks. And I'm going to take a look. I do see one question in the Q&A, and it says, in case of my priority date is not current, can I extend my TN status with an I-140 approved? How to maintain my status while I'm waiting to adjust status. So you should be able to extend something like a TN if you have an I-140 pending. Definitely when you file your I-140, you should always indicate that you plan on doing consular processing, because the issue with the green card is not so much that you want a green card. That is permitted to have be on a non-immigrant visa and want a green card. The issue is entering the United States with the intent to adjust status. That's what's not permitted. So that's so generally speaking, if you have an I-140 and it's been approved and you're renewing your TN, it's obviously going to be better if you can try to arrange it so that you don't have to renew your TN during that process. But if you did have questions at the border, you would want to explain to them that you don't plan on adjusting status in the United States, that you're going to do consular processing, and you've indicated on your I-140 that you plan on doing consular processing, and that's really the only thing you can do. The other thing you can do is you can just extend in the United States. So then that's definitely not going to be an issue, right? You won't have to worry about going to a border. You can just extend the TN, within the United States. So that's something to consider. And I don't see any additional questions, so we will end here. Thank you everyone for joining. And again, we're going to send you a copy of the presentation, a link to the guides, a link to set up a consultation, the actual webinar on our YouTube channel. We do encourage you to subscribe. Appreciate you joining, and look forward to dealing with you in the future. Thank you. Bye-bye.